Court of South Africa, Free State Division, Bloemfontein, is confirmed. 2. Section 26(1)(a) to C of the Births and Deaths Registration Act 51 of 1992 is declared unconstitutional to the extent that, in violation of Section 9(1) of the Constitution, it violates irrationally on the ground of gender, and to the extent that, in violation of Section 9(3) of the Constitution, it unfairly discriminates on the ground of gender by failing to afford a woman the right to have her spouse assume her surname, failing to afford a man the right to assume the surname of the woman after marriage, failing to allow for a married or divorced man or widower to resume a surname which he bore at any time, and failing to allow a man, whether married or divorced or a widower, to add to the surname which he assumed after the marriage any surname which he bore at any prior time. 3. The declaration of invalidity is suspended for a period of 24 months to enable Parliament to remedy the defects by either amending the existing legislation or passing new legislation in order to ensure that all persons are afforded the right of assumption of another surname. Pending the coming into force of the new legislation or amendments to existing legislation designed to afford the right of assumption of another surname as set out in Section 26(1) of the Act, it is declared that the provisions of Section 26(1) shall not apply when a person after marriage assumes the surname of the spouse with whom such person concluded a marriage, or after having assumed such surname, resumes a surname which they bore at any prior time. B, a married or divorced person or a widow or widower resumes a surname which they bore at any other time. And C, a person, whether married or divorced, or a widow or widower, adds to the surname which they assumed after the marriage any surname which they bore at any prior time. 5, should Parliament fail to correct the defects in the 24-month period, paragraph 4 of this order shall continue to operate until remedial legislation, if any, is brought into operation. 6, the first respondent is ordered to pay the applicant's costs in this court, including the costs of 2 counsel where so employed. I hand down the judgment.